in-depth exploration of Rule 34, Judgment on the Pleadings. Whether you're a legal professional, a law student, or simply interested in the intricacies of the judicial process, this video will provide a comprehensive overview of an essential aspect of civil procedure.
In the realm of civil litigation, Rule 34 serves as a crucial mechanism for parties to request and obtain relevant documents and tangible evidence from one another. However, when the pleadings fail to present a viable dispute of material fact, a party may seek a judgment on the pleadings, effectively ending the case without the need for trial.
What exactly does this rule entail? How does it operate within the framework of civil procedure? And what are the strategic considerations for both plaintiffs and defendants when invoking or challenging the motion for judgment on a pleading? In this video, we'll break down the components of Rule 34 of the Rules of Court, examine the landmark cases that have shaped its application. By the end of this presentation, we'll have a clear understanding how Rule 34 functions and its significance for the legal landscape.
So join us as we delve into the world of civil procedure and uncover the pivotal role of Rule 34, Judgment on the Pleadings.
True, but nothing but the truth, so help me God.
Now, it is respectfully prayed that this honorable court render a judgment on the pleadings.
What is judgment on the pleadings? Provided under Section 1, Rule 34 of the Rules of Civil Procedure, judgment on the pleadings is a judgment rendered by the court prior to a verdict because no material issue of fact exists and one party or the other is entitled to a judgment as a matter of law.
This occurs when an answer fails to tender an issue or otherwise admits the material allegations of the adverse parties.
Judgment on the pleadings is not applied to following cases concerning marriage, like declaration of the nullity of marriage, annulment of marriage, and divorce of marriage. For this involves the very sanctity of marriage and must be adjudged with support of evidence and proof. Hindi ko na po matandaan, Your Honor.
That is all the questions I have at this time. Please answer any questions the defense may have for you. Attorney Rivera, Your Honor, may it please the court would like to take a chance to begin questioning the witness.
Attorney Rivera, you may now begin your question.
Thank you, Your Honor. The defendant provided, in fact claimed in questions as to its answer the validity of the legal capacity of the plaintiff in this case, which is Miss Alice. So, Miss Alice, for the record, are you a Filipino? Your Honor, I would ask the court to please direct the witness to answer the question which has been asked.
Sustained. The court hereby directs the witness to answer the question being asked.
Your Honor, ako po ay Pilipino. Nag-iisa po ang passport ko. Ako po ay Filipino passport holder.
So you are a Filipino? I will be glad to withdraw the question, Your Honor. Miss Alice, where do you exactly live in the Philippines?
Your Honor, nakapit ako sa farm.
Where exactly is that farm located?
The farm is located po in General Santos.
Your Honor, I would beg the court's indulgence for a moment, please. Let me show you what has been previously marked as exhibit number 5. Can you identify this document, Miss Alice?
Yes, Your Honor, my birth certificate.
I believe a proper foundation has been laid. You may continue your questioning.
Is this a fair and accurate representation of your nationality that is being questioned?
Yes, Your Honor.
Here, the birth certificate provides that she is a resident of the Philippines from the time she was born. In fact, was born healthy and to a Filipino couple, Mr. and Mrs. Chu. Thus, Miss Alice has a legal capacity to sue. Your Honor, this time, the plaintiff would offer exhibit number 5 into evidence. Its authenticity has previously been stipulated upon the birth certificate of Miss Alice.
Exhibit number 5 is hereby admitted to evidence.
For no further questions for this witness, Your Honor, I would ask that the witness be excused.
Witness may be excused.
Thank you, Your Honor. Your Honor, I have here the copy of the answer of the defendant, Ms. Risa Chu. In their answer, the defendant admitted the obligation and clearly stated that she was asking the given an extension of time for them to fulfill their obligation. Said answer has not tendered any issue, and in fact, it can be read therefrom that the defendant admitted the obligation and is only questioning as to the nationality of Miss Alice. Consequently, the judgment on the pleadings may be rendered at this point, Your Honor.
Please continue.
Now, it is respectfully prayed that this honorable court render a judgment on the pleadings.
It is provided under the rules that when it is apparent that the answer fails to tender an issue or otherwise admits that the material allegations on the adverse party's pleadings, a motion to render a judgment on the pleadings may be granted. So therefore, the motion is granted.
Thank you, Your Honor.
So therefore, in the case of Asian Construction and Development Corporation versus Senadal Corporation, GR number 181676, decided June 11, 2004, for complaint for sum of money filed by Senadal Corporation against Asia Construction, where such transaction between them was executed through a memorandum of agreement. In the course of such agreement, payments were made. However, an outstanding obligation of $615,000 balance.
The Asian Construct refused to pay as to its failure to comply with the demand of the outstanding balance despite receipt of repeated demands through a demand letter of Senadal, compelling Senadal to file a complaint for a sum of money. In its answer, the defendant argues that the certificate of non-forum shopping was erroneous. Plaintiff is a foreign entity and has no legal capacity to sue. And due to fortuitous events, Asia Construct could not pay its obligation.
Any of its defenses, Asia Construct failed to refute the existence of the memorandum of agreement and the existence of the Senadal's claim, providing that they indeed admit to the existence of the allegations set forth in its answer. Then, the plaintiff moves for the judgment on the pleadings. The regional trial court ruled in favor of the plaintiff. The Court of Appeals upheld the decision of the regional trial court. Unsatisfied, the defendant raised the matter seeking resolution to the Supreme Court with the question of whether the judgment on the pleadings is proper. However, the Supreme Court sustained the judgment of the regional trial court and the Court of Appeals. The judgment on the pleadings is deemed proper. As to issue for judgment on the pleadings, the answer fails to tender an issue, whereas in summary judgment, there appears to be an issue but not a genuine one. As to basis for the judgment on the pleadings, judgment is rendered only based on the pleadings without consideration of additional documents. Whereas, for the summary judgment, judgment is made not only based on the pleadings but also using the affidavits, depositions, and other documents presented by the movement of the motion.
As we've explored, Rule 34, judgment on the pleadings is a pivotal aspect of civil litigation, offering a pathway to resolve cases efficiently when no genuine dispute of material fact exists.
Understanding the nuances of this rule can empower legal professionals to navigate the complexities of civil procedure with greater confidence, whether you are preparing to file a motion or anticipating one. The strategic considerations and legal precedents we have discussed are invaluable tools in your legal toolkit.
We hope this presentation has provided you with a comprehensive understanding of Rule 34, Judgment on the Pleadings, its application, and its significance with the judicial system.
Thank you for joining us on this journey through the intricacies of civil procedure.
Stay informed.
Stay prepared.
And continue to delve into the fascinating world of law.